Pre-transaction restructurings for S corporation targets via an F reorganization provide various potential benefits to sellers and buyers. The overall transaction plan generally requires the seller of an S corporation target to engage in some pre-transaction restructuring. Generally, those steps are: first, the shareholders of a target S corporation form a new target holding corporation via contributing the shares of Target to Target Holding in exchange for all of Target Holdings shares. And second, Target elects to be a qualified Subchapter S subsidiary, which effects a deemed tax-free liquidation of Target into Target Holding and extends S corporation status to Target Holding per Revenue Ruling 2008-18. These are all non-taxable events, treated as an F reorganization under federal income tax law. A popular additional step after the F reorganization steps above would be to convert Target under a state conversion statute from a corporation to a limited liability company. The timing of this step is generally at least 1 day after the steps discussed above. As a wholly owned LLC, Target would remain a disregarded entity for federal income tax purposes. The conversion of a qualified Subchapter S subsidiary into a single member LLC has no federal income tax consequences. The conversion is most often completed when the buyer is a pass-through entity, and it is preferred not to have Target as a C corporation post-closing. It also protects the buyer's basis step-up if Target inadvertently failed to qualify for S corporation status in the past, or the QSub election for Target was not properly executed. After a pre-transaction restructuring for an S corporation target via an F reorganization, the effect of the QSub election treats Target as a disregarded entity for federal income tax purposes. The timing of the QSub election is important. Target Holding elects to treat its subsidiary as a QSub by filing a Form 8869, Qualified Subchapter S Subsidiary Election. The effective date of the QSub election generally cannot be more than 1. 12 months after the date the election is filed, or 2. 2 months and 15 days before the date the election is filed. The Form 8869 should be filed by Target Holding with an effective date simultaneous with the date of the contribution of Target shares to Target Holding in exchange for Target Holding shares. Since Target Holding was formed specifically via the contribution of the Target shares, that contribution date would also be the legal formation date of Target Holding. Revenue Ruling 2008-18 provides that a merger qualifying as an F reorganization of an S corporation into a new corporation that also met the S corporation requirements did not terminate the S election. Therefore, an election of S corporation status on Form 2553, election by a small business corporation, is not required for Target Holding. A new federal EIN is generally required for Target Holding, while Target retains its existing federal EIN. The IRS redesigned Form 8869 in December 2008 and added a question to confirm whether the QSub election was being made in connection with an F reorganization described in Revenue Ruling 2008-18. The purpose of this revision is presumably to alert the IRS that there will be no separate S corporation election for Target Holding, since Target's S corporation status continues in effect for Target Holding after it becomes the parent of Target. The IRS makes clear in the instructions to line 14 of Form 8869 that a Form 2553 is not required to be filed by Target Holding as the parent. Pursuant to the F reorganization, Target Holding will file a full-year uninterrupted return inasmuch as the F reorganization does not break Target's tax year, and Target Holding is deemed a continuation of Target. That full-year federal income tax return is filed in the name and federal EIN of Target Holding. Target's federal income tax return for its immediately prior year would be its last. It would not file any further returns in its name and federal EIN.